I'm going to call this meeting to order. This is the meeting of the Township Officers Electoral Board, number 2013, Township Officials Electoral Board, number 1. The matter of objections by John D. Stebbins versus Laura Sandifer. And it is 2 o'clock on Thursday, January 10th, 2013. Would you call the roll, please?
Carol Elliott, Township Supervisor.
Here.
Robert Lewis, Township Trustee.
Here.
Phyllis Clark, Township Clerk. Here.
Okay. The next agenda item, and we also have additional agendas up here if anyone needs one. I also want to explain Mr. Grosser's presence here. He is here for the purpose to provide technical support in interpretation of the rules that we are going to be adopting. He's not here to provide any legal advice on decisions that this board makes. Any decisions will be made by the three of us. Excuse me. And we also have a court reporter here. Next agenda item, adoption of rules of procedure for the introduction of evidence and presentation of arguments. We distributed copies of the rules, and if there are any suggestions, additions, I would entertain those.
I just had one clarification. In the rules, it stated audio, and in this particular case, it's audio and visual. Is that a problem? Okay.
No. Okay. Any other suggestions or questions? Okay, then I guess we'll need a motion for adoption of these rules.
Sorry to interrupt.
Yes.
Would this be an appropriate time for me to just note my objection to the record to the proposed rules? I don't want to get off on the wrong foot here early, but I'd just like for the record to note my objection to the proposed rules.
I think that would be fine.
Thank you very much.
Okay. That's, the record will note that Mr. Beckett objected to the rules themselves?
Yes,
okay.
Thank you.
Okay. Okay, we need to vote, don't we? Or we have a motion? Okay, let's have a motion for the rules.
I move to accept the rules as presented.
Okay.
Second.
Any more discussion? All those in favor say aye.
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 Those opposed? That motion carries. Next on the agenda, we have the presentation of evidence and arguments by John D. Stebbins, petitioner, objector, and Laura Sandifer, the respondent candidate. And we will start with the petitioner. If you want to go ahead and speak into the microphone. And also, just according to the rules, feel free to question or ask questions of Mr. Stebbins and any party that's speaking. Is up there?
I wanted to start with per 10 ILCS 5/7-10, a voter may not sign petitions for candidates from more than one political party for the same political election. If a voter does not sign a political party petition, he may sign one independent candidate's petition for each office to be elected. In Exhibit 1, there are signatures of petitioners of the Democrat Party. Exhibit 2 shows where they signed elsewhere. If you want me to, I can go line by line of each one of them. I don't know how you want it.
Also, if it might be helpful if you refer to your petition as to what you're referencing here.
Exhibit 1 is candidate Sandifer's original petition. And Exhibit 2 are the petitions for the rest of the Democrat, almost all the rest of the Democrat city clerk, mayoral candidates, and the rest of the city council members. They have, if you want me to go through one by one, on Robert Gatsky's petition, there were two people that signed for both the Democratic Party and the Independent Party. On Laura's petition, it would be page 5, line 7. On Mr. Gatsky's petition, it was page 2, line 12. On Laura's petition, the second person was page 11, line 5, and they signed Mr. Gatsky's petition on page 4, line 16. On Phyllis Clark's petition, the one they signed on independent was on Laura's page 6, line 4, and on Ms. Clark's petition, it was page 11, line 1. On Charlie Smythe's petition, on Laura's side, it was page 5, line 4. The same person signed on page 1, line 17.
At this point, I'm going to raise an objection that you're hearing an argument that is outside the petition itself. The only allegation about 5/7-10 was that the allegation that Laura Sandifer had signed the petition for Mr. Bill Brown. Thank you.
Okay.
In my objection that was referenced, number 7. Oh, I'm sorry. Number 3 and number 4.
Okay, I lost track of where we were.
On the, for his objection, or just?
No, for.
Where I was?
Yeah.
I believe the last one I did was, I was on Charlie Smythe. Last one was page 5, line 4 for Laura, page 1, line 17 for Charlie Smythe. Do you want me to continue?
Let me ask the other board members, because the candidate's attorney will have a chance to respond. Do we want to let the petitioner continue?
I'd like to hear him out, and then
Yeah, I
if
think
there's a
that's-
rebuttal afterwards.
Yeah, I think
Go ahead.
there'll be a chance to
And if it'd be
answer to this.
more effective, I can give every one of you a copy of this along with the attorney. If you don't want me to read through each one of these, of the 26, I can do that, or I can hand you a written copy of it, whichever the board prefers.
I think it might be helpful to have both.
Okay.
Thank you.
The next one under Charlie Smythe is, they had signed for Laura, page 12, line 1. Signed for Mr. Smythe on page 4 of line 4. They had signed under Laura's page 13, line 3. for Smythe, page 4, line 8. Laura, page 14, line 8. Smythe, page 1, line 5. For Laura, page 16, line 2. For Mr. Smythe, page 4, line 10. The next was for Leslie Stratton. For Laura, it was page 4, line 3. For Mr. Stratton, it was page 5, line 3. For Laura, it's page 16, line 1. For Mr. Stratton, page 5, line 4. The next petition was for Laurel Pressing. For Laura is page 5, line 4. Ms. Pressing, page 7, line 13. For Laura is page 9, line 3. For Ms. Pressing, page 6, line 10. For Laura is page 9, line 4. And Ms. Pressing, page 9, line 18. For Laura is page 10, line 1. Ms. Pressing is page 6, line 13. For Laura, it was page 10, line 4. Ms. Pressing, page 6, line 12, I'm sorry. The next one would be Laura, page 10, line 2. Then Ms. Pressing is page 6, line 14. For Laura is page 10, line 14. Ms. Pressing, page 14, line 11. For Laura is page 14, line 6. Ms. Pressing is page 6, line 1. For Laura is page 15, line 15. And the corresponding was page 1, line 20. After that was for Bill Brown. Laura had one on page 8, line 10, and on Mr. Brown's is page 1, line 3, and then the final petition was Dennis Roberts. Laura had page 15, line 15, and they had signed the same one for Mr. Roberts on page 3 of line 15. Additionally, 10 ILCS 5/7-10 and 10-2 and 10-4 states petition signers must be registered voters in a political subdivision in which the candidate is seeking nomination or election. Exhibit 1 on page 1, line 6, and 13, page 2, line 10, and on page 22, line 14, do not reside in Cunningham Township. Additionally, the following registered voters I could not find registered to vote that lived in Cunningham Township, and I can read off those. They're at the top of that paper I gave you. I can read those off as well. I believe there are enough signatures between signing both for an independent candidate and for a Democratic candidate and not being registered to vote in Cunningham Township is enough to leave our petition invalid for not having enough signatures. Would the board like me to read them off orally as well?
As far as the page numbers or the
The
addresses?
page and line numbers of the non-registered at the address.
I think that would be helpful if you have the specific
Yep, and
petitions that you're talking about.
they're at the top of the sheet that I gave you as well, the very top. The page 1, line
Okay.
8.
Okay, I see, yeah. All right, okay. Would you like him to read the? Yeah,
Okay.
why don't you go ahead?
Sure. Page 1, line 8, 10, 11, and 15. Page 2, lines 2, 3, and 6. Page 6, lines 3. Page 7, line 15. Page 8, line 9. Page 9, line 1. Page 12, line 6. Page 13, line 10. Page 15, line 10. Page 16, lines 5 and 11. Page 17, lines 1, 8, 9, 15. Page 18, lines 4, 5, 8, and 11. Page 20, lines 1, 9, and 15. Page 21, lines 2, 6, and 15. and page 22, lines 1, 6, 15, and page 23, lines 3, 10, and 15. It is my belief that candidate Sandifer is in violation of 10 ILCS 5/10-3. Independent candidates are defined as those individuals who are not candidates of any political party, but who are candidates in an election in which parties' candidates may appear on the ballot. I do have a court case in Colton versus DuPage County Officers Electoral Board, the appellate court of the 2nd District. It defines party switching and upholds 10 ILCS 5/7-10, and I have copies of that court case if you guys would like to have a copy of that as well.
Sure. Thank you.
If you're ready for me to proceed, or do you want to check to look through that, or?
Do you want to give us a summary of what this says?
The very short version is that the County Electoral Board sought review that reversed their decision to exclude a state Senate candidate from the ballot from the upcoming election. And it was that the candidate had switched parties within a short time frame, basically is how it reads, and so he could run as his new chosen party. And the judge did not allow that. And I think the page 7, the last paragraph, page 7, and the first paragraph, it goes on to page 8, reads, for the reasons stated, we conclude that the limitation on candidate party switching found in the statement of candidacy portion of section 7-10 of the code, which requires candidate attest to being a qualified primary voter of the party whose nomination the candidates seek, is now viable in light of Sperling, which Sperling said that 2-year time period was too long a period for somebody to be able to switch parties. Because the petitioner fails that statutory requirement, they agreed that he was not eligible to be placed on the ballot. And further to show that she is party switching, candidate Sandifer is currently appointed as a Democrat on the Champaign County Board of Review. Furthermore, she was elected Democrat Precinct Committeeman for Cunningham 13th Precinct until her resignation of that duty on the day she filed her petition as an independent candidate for Township Assessor December 26, 2012. And I have shown that she was a Democrat Precinct Committeeman, and that's in Exhibits 3 and number 5. Furthermore, candidate Sandifer ran and filed for Township Assessor on the Democratic Party in Cunningham Township for the February 26, 2013 primary, which I have as Exhibit 4. At that time, she declared she was running for office under the Democratic Party. She signed her statement of candidacy, which is also in Exhibit 4, and states in part that I'm a qualified voter therein an unqualified primary voter for the Democrat Party. And then secondly, to show that she was a Democrat, she signed a Democrat petitions for Bill Brown, which is on page 3, line 13 of Mr. Brown's petition. She also signed Leslie Stratton's petition on page 5 of 5, and she had signed her own petition for Democrat when she was running for Township Assessor under the Democrat label. And she did that on page 4, line 1. And that's in Exhibit 4, is her original petition. The language at the bottom of the petition state, we are undersigned members of and affiliated with the Democrat Party. Therefore, she declared her Democratic partisan for this election cycle. And that's what that 10 ILCS 5/7-10 talks about. Furthermore, I object to the candidate Sandifer's petitions based on 10 ILCS 5/10-4. A petition circulator may not circulate for an independent candidate or candidates in addition to candidates of an established party. Kevin Sandifer circulated petitions for both the Democratic Party and an independent candidate. That can be seen in Exhibit 1, pages 2, 6 through 8, 17 through 20, and in Exhibit 4 on pages 4 and 5. Laura Sandifer circulated petitions for both the Democratic Party and an independent candidate, and that can be in Exhibit 1, pages 1, 4, 12, 23 through 21 through 23, and Exhibit 4, pages 1 through 3. In closing, I ask that you examine the exhibits that I have mentioned, along with the appellate case, court case, Coulter versus DuPage County Officers Electoral Board, and make a ruling that the candidate Sandifer petition for nomination for the office of Township Assessor as independent candidate in Cunningham Township are insufficient in law and in fact, and due to any or all reasons stated in my objection, that her petition for nomination are invalid, and the name Laura Sandifer not appear and not be printed on the ballot as independent candidate in Cunningham Township for the April 9, 2013 election.
Okay. Questions from board members? None, not yet? Okay. All right, thank you. Mr. Beckett?
Good afternoon. If I could just take a moment. Lawyers travel with papers, and I'm going to kind of spread mine out a little bit, or they'll fall at some point. Thank you. I am Andrew Beckett. I am here with the candidate Laura Sandifer. At the outset, I would move for a directed finding for the candidate. No evidence has been presented to this board. Arguments are not evidence. Exhibits were not offered. Exhibits may have been referenced, but no exhibits were presented to the board with any sort of indication that they were accurate, complete, or verifiable. The candidate did not even receive the exhibits until yesterday and only received those upon request. They were not served upon her. Some of the exhibits that Mr. Stebbins attached to his petition appear to have his own handwriting on them. So at this time, given that the burden is upon the objector to present evidence, I think that the board should enter a directed finding against him. Arguments are not evidence. We are not supposed to just simply assume that the things that he says to be true are true. Moreover, although he references voluminous exhibits in the petition itself, he did not highlight any name except that of Bill Brown and Laura Sandifer, of which he took particular issue. The voter registration rolls have not been offered. The demonstrative exhibit that was just referenced that says Exhibit 1 Laura Sandifer petition not registered at address, first of all, suggests to me that Mr. Stebbins did not offer the exhibits attached to his petition as exhibits here today. He may have referenced them in his petition, but the only exhibit he offered you here today is a demonstrative exhibit which makes various references to various names, but has no evidence to support it. As I said, it's just demonstrative. Moreover, if you look at the idea not registered at address, the registration rolls have not been offered, not been examined, no comparison has been made. We're just supposed to assume that because page 1, line 8, etc., was typed on a piece of paper, that evidence has been offered, and unfortunately it has not. In addition, there is reference to the other petitions of the other individuals, and I believe that those petitions have not been offered appropriately either. So in the event that we are going to proceed past this moment, I do have any number of things to say on the topic at hand, but under the law, the candidate has no obligation to present evidence. The objector does have an obligation to present evidence. Arguments are not evidence. The petition itself and allegations made therein are not evidence, and you cannot go beyond what is in the stated language of your petition itself. So at this time, I'd make a motion for a directed finding for the candidate.
Excuse me. I need to ask Fred a question. In order for us to rule on this, does one of the board members need to make a motion to consider Mr. Beckett's motion? Or what is appropriate here?
The rules make it clear that this is not a court of law, that the rules of evidence and the rules of procedure that apply in court do not apply here. There is no such thing in your rules as a motion for a directed verdict. What Mr. Beckett says might be applicable if this were a judicial proceeding, but it is not. The whole idea of the rules is to make the presentation of evidence informal. And let me say, I should have said to start with, you should not take my comments as suggesting or favoring one party or the other. I think it's appropriate when everything has been presented that you accept all exhibits that have been offered. You can look at the exhibits. You can decide what weight, if any, you think an exhibit should have. You can accept it, you can reject it. See county clerk records. Anything you think is necessary to reach a fair and reasonable decision based upon the evidence, the documents, and of course it's, I think, all going to be a matter of your evaluation of the documents. I think the exhibits appropriately considered are what was submitted with the petition, and anything either side chooses to offer you today. The practical matter, I think, when everything's been presented, either side wants to present today, you'll probably want to take recess to new date and take time to for each of you to look over everything. Then there are various ways that you can proceed at that point, which I suppose you can discuss after everybody has presented what they want to present. But formal rules of evidence, formal procedures made in court are not things that you can establish and we don't apply.
May I respond, please?
Sure.
First of all, I agree that often in these cases the formal rules of evidence do not apply. At the same time, the law does require that evidence be presented. The law requires, for example, that affidavits can be offered to this tribunal, assuming that they have an appropriate level of reliability as opposed to calling live witnesses. That's an example of where the rule of a courtroom does not necessarily apply here. However, simply saying, I believe something to be true, is not evidence. A court has an obligation to review the record that is made here. If a party is displeased with what happens here and takes it to the court, and at the moment the court would have nothing at all to go on except for arguments that had been made. And as I stated, the objector has the burden to present evidence. If I may have just a moment. The Electoral Board has the authority, if Mr. Stebbins had asked, to set up a review of the voting rolls, and your own rules that were adopted even called for that there could have been a representative from each side going and reviewing those records and then having a report back about what those records showed. That did not happen here. And therefore, since the objector has already closed his case with whatever evidence that he wanted to offer, I once again do assert that this board has no choice, but to find against him. The other thing that I would note is that I have objected to the rules, and this was one of the rules that I objected to, was that this board could find for the objector on grounds outside of his petition, that certain evidence was considered to already be evidence without any opportunity to decide what was or was not evidence and what was or was not reliable. So I did object to those rules, and I continue to object to those rules. And with due respect to counsel, it would be entirely inappropriate for this council, this board, to go do a review of its own, to do some sort of a fact-finding mission to find out whether or not the objector had proven his case. That is not the procedure. The parties are supposed to offer evidence to you, not put it upon you to go determine whether or not you think that one of us has a good case. So I continue to argue that the directed finding should be made for the candidate, but if I am unsuccessful in that motion, I do have other things I would like to say. Thank you.
Okay, all right. I might point out that these rules were not adopted until today as well, officially by this body. Do either of the board members wish to address Mr. Beckett's request for a directed verdict? Okay.
We have stated in the person making the statements earlier that the 10 ILCS 5-7-10, in reference to that, that's a state statutory requirement. Is that not correct?
Yes, sir. 5/7-10 is a statute of the state of Illinois.
Okay. In reference to that, specifically, it was specified that the individual was specifically in violation of that statutory requirement. That is a legal requirement, right?
Well, sir, first of all, thank you for the question. I believe that there is no evidence been presented to show whether or not a violation of 7-10 occurred. An allegation has been made, and then whenever the objector had the opportunity to present evidence, he presented absolutely none. There are no facts. There is no evidence before this board, and it is not upon the candidate to come in and prove whatever he wants to allege in his petition. The burden is not upon us. The burden is upon him. When presented with his opportunity, he chose to use it by just restating the arguments he had made before and not presenting any evidence. And so if my motion is denied, essentially what is happening is that the candidate is being told, you have the burden of proving him wrong. However, sir, I do want to say that I have any number of things to say about that specific statute, and assuming that my motion is denied, I have much to say about why I do not believe there has been a violation of this statute. But I don't believe that's the question before, because I don't believe we have any evidence to apply to the facts. To apply to the law at this time. So I hope that answers your question. I'd be happy to answer more if I can be of any assistance.
Well, there's an implication. And since this is not a court of law, maybe you want to articulate on that.
Well, I would say that there's an allegation, but if this is the appropriate time, I'd be happy to discuss 5/7-10. I intended to make a bit more of a presentation if my motion was denied, but I don't want to not answer your question now. Would you like me to discuss 5/7-10?
I'd like to hear what you have to say.
All right. Well, what I have to say about 5/7-10 is that the relevant language of that statute is that a qualified primary elector of a party may not sign petitions for or be a candidate in the primary of more than one party. 5/7-10 makes no reference to independent candidates anywhere in the statute. The case that was cited to you a few moments ago, let's see, which case was it? The Cullerton case was about a Republican who had voted in the primary. No, I'm sorry. He had voted in the Democratic primary and then tried to run as a Republican. Here, we have no allegations such as that at all. 5/7-10 says that party affiliation is, well, not part, yes, I'm sorry, 5/5-30. We're not even talking about 5/7-10, but party affiliation is established by a voter through a specific declaration at the primary election whenever you go to vote. You go up to the table and they say, who are you, and what party are you with? And then once you do that, you're locked in for that, what they call election season, and by a candidate when securing placement on the primary ballot. The candidate here did not secure placement on the primary ballot. Had the candidate secured placement on the primary ballot coming up, then she would not have had the ability, particularly if she had lost, to then try and run again at the next election, at the consolidated election. This statute comes into play a lot more with the general and the general election years, where you've got a much greater gap for someone to try and mount something new, perhaps before the November election. But that statute simply just does not apply here. And some of the statements that are made in the petition aren't contained in the law. And you don't get an exact reference to, not quotes, of the statutes that are listed. So that'd be my response to that particular line of attack. But at the same time, I would say again, there is absolutely no evidence to show what did or did not happen here. No evidence has been offered at all.
What was that statute citation about party affiliation?
Party affiliation is established by a voter through a specific declaration of the primary election. 10 ILCS 5/50-3. Also 5/7-43A, 5/7-44. And by a candidate when securing placement on a primary ballot. And that statute is 10 ILCS 5/7-10. Many of these statutes and cases do deal with political parties, not necessarily with independents. And so someone may say to themselves for a moment, well, that doesn't seem entirely fair. But it's extraordinarily fair, because the legislature has gone out of its way to place hurdles on independent candidates and new political parties that aren't placed on the two existing political parties. So there's a balance there. And I think that either you can assume the legislature knew what it was doing, or if you're a person who's reluctant to ever assume that, this is a situation where you would not just be telling the candidate that she's not allowed to run for office. You would be telling every person who signed one of her petitions, your voice is being silenced. You're telling the voters that they don't get an option as to who they would like to vote for, and you're disenfranchising voters whenever you tell a candidate that they're not allowed to run. So if there is confusion in a statute, if you think, boy, I'm not sure what the legislature was up to there, you have to err on the side of the candidate, because of the First Amendment rights of the citizenry for free association and for the rights of the voters to vote.
Okay, Robert, do you have more questions?
I'm good, thanks.
Okay, Phyllis, do you have questions?
Yeah, I guess the question that I have from what was presented is that there was more of a question as to whether or not the required signatures were in place for an independent candidate. Dan gave a whole list of questions as to whether or not the persons that signed her petitions as an independent, whether they were legal to do that simply because they might have signed the petitions of a Democrat. So I guess that's what my question and concern would be is if we were to go through these petitions and find that any of these things was out of order according to what the law says, then would she still have enough signatures to be considered on the ballot for an independent?
The first thing that I would say, and I apologize for the broken record, is we don't have evidence to review. But setting that aside and getting at the heart of your question, the first thing that I would say is that, again, it would not be appropriate for this board to go out and do an investigation for things that were not offered. There was a procedure through which there could have been a review of the voter rolls, and that did not occur. The second thing that I would respond is that, as I said, 5/7-10 says that a qualified primary elector, which for this instance we can pretty much just say is a voter, of a party may not sign petitions for or be a candidate in the primary of more than one party. But you have no allegation here that anyone has signed for more than one political party. That statute does not reference independent candidates. The other thing that I would say is that we don't have a situation even within the same primary. We have two completely separate elections. We have allegations that people were signing the petitions for the consolidated primary, and then we have allegations that people were signing petitions for the consolidated election. We don't have allegations that people were party switching and going crosswise during the exact same election. And so I just don't think that that statute applies, or that that concern applies, even if there was evidence here to support that argument. Thank you.
Okay, I'd like to respond to that. It's my understanding that in the objection, it refers to election cycle, which would include the primary and the general election.
The statute doesn't, though. There's just simply things in this petition which don't quote the statute.
Okay, if there are no other questions, we should probably respond to Mr. Beckett's request for a directed verdict.
You
and
should
there's
not respond to
Okay.
Mr. Beckett's request for a directed verdict.
Okay,
I don't intend to argue with or against Mr. Beckett, but as I pointed out, we're not in court. There is no such thing as a
Okay.
motion for directed verdict, and somebody can say the same thing 10 times. It's not going to change the fact that there is no such thing. I have not seen any of the exhibits. I don't know what's in them, but exhibits have been presented to you with the petition. Some additional papers were presented today. Mr. Beckett is free to present anything he wants. I haven't seen what he has in mind to present, but I think he should be allowed to present anything he wants.
okay.
As I said before, I think what you'll ultimately be looking at are the exhibits. Mr. Beckett says argument is not evidence, and that's correct. If somebody is testifying, what he testifies to is evidence. If he's expressing a legal opinion, which both sides, of course, necessarily will do, that's their legal opinion. That's the argument. But at this point, I believe you should treat this as Mr. Beckett's opportunity to present anything he wants. After that, Mr. Stebbins should be allowed to present anything he wants in rebuttal, if anything. At that point in time, you'll have the documents that, between them, they think you should look at.
Okay. All right. Would you like to just continue with your objections, and we will not make a ruling on your request?
Very well. I'll proceed in a moment, but I guess I would at this time say that these exhibits were never served on the candidate, that these exhibits were not even offered today, that I managed to obtain a copy yesterday, so I have not had the opportunity to go through and compare whatever records we're claiming have been offered at evidence, and that once again, I just don't believe you have any evidence, but I will go ahead and proceed. Thank you for the opportunity to do so. Mr. Stebbins raises essentially 4 arguments in his petition. The first is that Ms. Sandifer allegedly signed the petition of a Bill Brown. There's no evidence of that before you, but setting that aside, we've already discussed the statute that Mr. Stebbins cites, 10 ILCS 5/7-10, which states that a qualified primary elector of a party may not sign petitions for or be a candidate in the primary of more than one party. We do not have any allegations that has occurred here. And even if we go into these other individuals, which were not listed in the petition that Mr. Stebbins brings up in his demonstrative exhibit today, there is no allegation that these individuals have signed the petitions for a candidate in more than one primary of more than one party. Ms. Sandifer is not a candidate for the primary. She is a candidate for the consolidated election. Moving on to Mr. Stebbins's second argument, I once again argue that Mr. Stebbins had to proceed on the face of his petition. The face of his petition did not identify who it is that he took issue with. Within the petition, it cites the various page numbers that he takes issue with, but they are contradictory and do not match up with each other, even within the same paragraph. Mr. Stebbins appears to have made some notations on these alleged exhibits. I don't know whether or not you all are supposed to accept his notations on these exhibits as evidence. The actual original petitions without his notations have not been offered, but they contain check marks and stars. I'm not certain what the meaning of those check marks and stars are supposed to be. There are question marks next to some of the names. I'm not sure if that means that Mr. Stebbins has a position as to the appropriateness of the signature, or if the question mark means that he is not certain himself. Some notations have been made and then crossed out. There is no way, even receiving the exhibits yesterday when I requested them, that the candidate could have any means of knowing which signatures Mr. Stebbins intended to actually quarrel with. You are bound to the face of your actual petition. You're not allowed in your petition to just list all of the grounds that could be raised for a challenge and to say, here are hundreds of names. I'm sure if we spend enough time on this, we'll find some that should be stricken. He doesn't even request that they be stricken. So I do not believe that on the face of his petition you can get into this argument about the signatures. Turning to the next argument raised by Mr. Stebbins, he seems to essentially basically be arguing, she's a Democrat, I know it, and therefore she cannot stand as an independent. And he offers 3 basis for that. The first being that allegedly Ms. Stebbins sits on the Board of Review and was appointed by the county board chair to hold a Democratic seat on the Board of Review. Mr. Stebbins has cited absolutely no authority for the premise that someone who holds a political office of a political party cannot change political affiliation in the very next election. If so, you would have a situation where if someone was holding an office for a current political party, they wouldn't be able to, during their current term, decide that during the next term they were going to run for an office as a member of another political party. The United States Supreme Court has found that you are allowed to party switch, that you have a First Amendment right to party affiliation and to who you choose to associate with, and so you can. You don't say to individuals who are currently holding a seat, you're going to have to sit out the next election cycle before you're allowed to run for another office, or you're permanently locked into the party which you previously affiliated. As to the second argument about being a precinct committee person for the Democratic Party, if we want to get back into that election cycle language that sometimes folks use but isn't necessarily in some of the statutes, Ms. Sandifer was not elected as a precinct committee person during this election cycle, and she has resigned that seat. And so I don't know that it has any relevance. There certainly has not been any statute or case law cited to suggest that having been a precinct committee person is a bar. The final argument seems to be that she filed a statement of candidacy as a Democrat for the primary election to be held on February 26th of 2013. The 10 ILCS 5/10-3 states a candidate for whom a nomination paper has been filed as a partisan candidate at a primary election and who is defeated for his or her nomination at the primary election is ineligible to be placed on the ballot as an independent candidate for election in that general or consolidated election. Ms. Sandifer was not defeated, and she withdrew her name from nomination, and the voters never ruled on that. And so there's no statute that has been violated for having at one time perhaps attempted to have been on the primary ballot. And once again, the statute does not reference the election cycle language that some folks hear. Mr. Stebbins didn't cite the statute 10 ILCS 5/7-43, but it seems to be part of where he was headed. And that statute states that a person who filed a statement of candidacy for a partisan office as a qualified primary voter of an established political party, or who voted the ballot of an established political party at a general primary election, may not file a statement of candidacy as a candidate of a different established political party or as an independent candidate for a partisan office to be filled at the general election immediately following the general primary for which the person filed the statement or voted the ballot. A person may file a statement of candidacy for a partisan office as a qualified primary voter of an established political party, regardless of any prior filing of candidacy for a partisan office or voting the ballot of an established political party at any prior election. I have to say that if you could keep up with everything I just read, you're a much better person than I. Sometimes when I hear those statutes, they wash over me. I am going to be filing a memo today that contains a lot of these arguments, has a lot of these citations, so you'll have the opportunity to read it again. But essentially, what that statute says is that a person who files a statement of candidacy for a partisan office as a qualified primary voter of an established political party at a general primary election may not file a statement of candidacy as an independent candidate for a partisan office to be filled at the general election immediately following the general primary. Now, the election code is very precise when it uses the terms primary, general election, consolidated primary, and consolidated election. They are different. They have different windows for when people are allowed to file their papers. There are different offices being filled, and there are different rules at play. And here, this statute, which on first blush you might go, oh, well, that might be relevant or a concern to this case, has nothing to do with it because it didn't discuss the consolidated primary or the consolidated election. So there simply is no law to say that this candidate's a Democrat and she's going to be stuck as a Democrat and she can't run as an independent. If you look at the actual statutes at play here, Ms. Sandifer, even if there was evidence, has not violated any of them. The last point that I'll turn to is this allegation that there were circulators of both the Democratic Party and independents. The first thing I would say is that once again we are looking at two different elections. We're looking at the consolidated primary and the consolidated election. The statutes that cited 10 ILCS 5/10-4 does go into what you can or cannot do, but it says no person shall circulate or certify petitions for candidates of more than one political party or for an independent candidate or candidates in addition to one political party, once again, to be voted on upon at the next primary or general election. So that pertains to the general election. If you turn to the next part of the statute, which actually does reference consolidated elections, it says, no person shall circulate petitions for an independent candidate or candidates in addition to one political or party with respect to the same political subdivision at the next consolidated election, with no reference to the primary. And there is no allegation, for example, that Ms. Sandifer was going around getting ready for the consolidated election and holding petitions for a new political party that she was trying to form and also for independence. So whenever you're looking at the actual election that Ms. Sandifer is on the ballot for, there is no allegation across the four objections raised that there has been a violation of any particular law. And as I've referenced in my earlier comments, whenever you're deciding whether or not you're going to take the rights of the folks who signed the petitions or the rights of the voter who may wish to vote for a candidate, you have to err on the side of the candidate, and you have to not silence an extension of the right to vote. I do appreciate the time that you folks have allotted me today. If I could just take a moment to make sure I didn't miss something off my list. May I approach? May I come up to your table?
Sure.
All right. Who should I give the original of the memorandum?
To the clerk.
There you go. Thank you. Thank you.
Is this the memorandum to which you referred that you want to file, or?
Yes.
Okay.
I would ask that my entry of appearance, this memorandum of law, be noted as a part of the official record.
Okay. Will the record reflect that Mr. Beckett offered his memorandum of law at 2:58 p.m. to the clerk, the board members, and to Mr. Grosser? And did you offer a copy to Mr. Stebbins as well?
I did.
Okay. And to Mr. Stebbins.
Are there any other questions I could assist any of you with? Thank you for all of your time. I appreciate it.
Phyllis, did you have any questions? Okay. All right. Mr. Stebbins? You have no rebuttal?
I would just say that when I turned in my objection originally, it had my evidence in there, and that's the evidence I would wish for you to look at. As for giving you all the registered voters in Cunningham Township, when I went through the records of the registered voters in Cunningham Township, it's about 1,094 pages. I felt it would be easier for me to give you the page and line number of each person who was not registered or had signed or did not live in the township, so that way it would be easier for the board to ask the county clerk for a copy of the voter for each of those people. That's all I have.
Okay. Any questions? Okay.
Let me make a few comments on suggested procedure. Mr. Beckett has furnished you with a memorandum, and that's fine. I think it would be appropriate to give Mr. Stebbins an opportunity to offer a memorandum if he wants to. Often that's done afterward. The fact that Mr. Beckett had it ready is fine. I still suggest that Mr. Stebbins be offered the opportunity, if he wants to furnish such a memorandum. The time limits in the election code to get us to where we are today are very short, but often there isn't much time before an election in dealing with these things, I believe. But I think there is adequate time for you to deal with this in an orderly manner. So I suggest giving Mr. Stebbins however long he wants, 5 days, 7 days, something like that. I think everything should be done publicly where you are deliberating. I suggest that it's be recessed to another date to meet here again. That will give you an opportunity to look at all the exhibits. You should formally accept all the exhibits offered with the petition offered today. I think that's what's contemplated by your rules. A suggestion that occurs to me just as we're sitting here, proceed any way you like. Your rules don't tie you down to the formalities that some units of government that have lots of these kinds of proceedings do. You may, for example, one of you, perhaps the chair of your board, to draft her thoughts on what would be appropriate findings and decisions and send it to the others of you to look at, but I think discussion of it should be public. You may want to have each of you write something up. You may want to wait until you've looked at all the documents and have another meeting and then decide how you want to proceed. I thought the idea of having the chair draft something for a start so that you have something to work with, and then when you meet, you can reject it, change it, whatever you like. It just seemed to me to be the most orderly way to do it, and the chair didn't know I was going to suggest that.
Okay, do you have any thoughts? I'm assuming since we're covered under the Open Meetings Act that we shouldn't be communicating with each other outside of this meeting, other than if I send you information, then the only discussion or response will be at our next public meeting.
I would welcome any suggestions, and maybe we can, if you want to draft something, that's fine with me, and we can articulate that to the general public at some point in time in the future.
Okay, Phyllis?
I agree.
Okay, all right. And per Mr. Grosser's suggestion, we could offer Mr. Stebbins a chance to also submit a memorandum if he wishes. Do we want to give him a specific deadline and then decide when we're going to meet again? Or do we want to give him a deadline right now and then set the next meeting date, dependent on our schedules and what our time limits are?
I think a reasonable time frame would be within the next 15 days.
I would object for the record on two grounds. The first being that the published notice said that there would be a decision today. I did not show up asking for a continuance. I came with everything ready. I met my clients for the first time on Monday and got my memo together. So I understand you'll probably allow him time to write the memo, but I think 15 days, with due respect, sir, seems very high. You know, I was up half the night last night getting ready for today, so I think a week's time would be certainly appropriate. Thank you.
A week's fine with me.
I don't think you could make a meaningful decision today, but I do agree that 15 days is probably a lot more than
I'm a little slow, that's all.
what you need in this case.
Yeah. Yeah.
For one thing, I have to have the ballot certified before the end of the month. So I think 5 days or this time next week would be appropriate.
I'm retired, you guys have to make the decision, so get it on. Tell me what you got to do.
Okay. And I think our rules do allow for us to continue this discussion, outside of what the agenda says. So I think we could decide to meet same time here next week.
Sounds
And if
good to me.
Mr. Stebbins wants to provide a memorandum of law anytime up until that point or at that meeting,
I think
but we would need to look at it for,
it'd
I
make
think we
more
would.
sense if he had a shorter date than the date for your
Okay.
next meeting so that you can consider it before you're here.
Okay. All right, I think that's appropriate as well.
I also requested a copy be sent to me.
Sure.
So that I can read it before the
Yes.
next meeting, too.
Yes, no, I think that would be appropriate. Okay. Do you want to give him, because we'll need time to look at it as well. Tuesday? Okay.
Give me a date.
Tuesday. Okay, Tuesday by noon or 5 o'clock?
Will that work for you?
5 o'clock.
5 o'clock, okay. So we will offer you the opportunity to present a memorandum of law in response to this by 5 o'clock on Tuesday, January 15th. And please get a copy to all the board members and to Mr. Beckett. And then we will hold our next meeting, assuming that we can have these chambers.
I'll check the calendar, and I will notify everybody of the time that we can be in here on next Thursday. Okay?
Are you going to recess to next Thursday?
Recess to next Thursday.
And you're going to formally accept all the exhibits?
Yes.
Yes. Yeah.
I would object to the record.
Object to what?
To exhibits being offered by Mr. Stebbins if they were not offered in his case in chief or proved up in any way. This is the same objection I've made. I'd just
Okay.
like to object to the record.
Okay. All right. All right. So is there anyone who will make a motion to accept the evidence provided with the petition by the objector along with the other exhibits he provided today?
So moved.
I'm sorry, I have to object again. Is this Mr. Grosser's motion? Mr. Stebbins hasn't even raised the motion that he wants as exhibit.
Well, I think it's up to the board to make the motions.
But I understand. But I
Okay.
object.
Okay.
So moved.
So moved.
Second.
Okay, any discussion? Okay, would you call the roll, please, Phyllis?
Carol Elliott?
Yes.
Robert Lewis?
Yes.
Phyllis Clark, yes.
Okay, and then we'll need a motion to also accept the memorandum provided by Mr. Beckett.
So moved.
Second.
Okay, any discussion? Would you call the roll, please?
Ms. Elliott?
Yes.
Mr. Lewis?
Yes.
Ms. Clark, yes.
Okay. All right, and just to note that Mr. Beckett objected to the acceptance of the documents provided as evidence. All right, is there anything else we want to discuss?
We got a clarification on time. That's the 15th of January, right?
The 15th is Tuesday, which would be Mr. Stebbins' deadline. The Thursday would be the 17th.
17th.
at 2 o'clock?
2 o'clock.
2 o'clock, tentative until I find out.
Right, okay, tentatively, January 17th at 2 o'clock here in the council chambers, pending availability of the chambers. Okay, anything else? Okay, if not, then I will adjourn this meeting at...
No, you're recessing the meeting.
I'm sorry, I will, do we need a motion to recess then?
So moved recess, please.
Okay,
Second.
all right. We've had a motion and a second to recess to the 17th at 2 o'clock p.m. Would you call the roll, please? Sorry.
Please.
Carol Elliott,
Yes,
Robert Lewis.
Yes.
Phyllis Clark, yes.
okay, all right.